Doctor, you initially saw Mr. Roy for the October 16th, 1996 accident on November 5th of 1997. Is that correct? Yes. From November 5th of 1997 through the date you took those x-rays, did you observe both clinically and according to the x-ray studies a degeneration in the subtalar joint of Mr. Roy's left heel? Defendant's counsel, objection. Leading and suggestive. The court overruled on that ground. Yes, I did. Would you share with us why it's significant in determining a prognosis for Mr. Roy, that is, what the future holds for him in terms of his left heel? Defendant's counsel, objection to form. The court, I'll take it. Well, that represents severe arthritis. It's a weight-bearing bone, and when you walk, it's painful. That's why I felt he would eventually come to a fusion of that joint to diminish his pain. Doctor, when you talk about a surgical fusion, what's the nature of the procedure you're discussing specifically, and why do you feel it's necessary, if you do, within a reasonable degree of medical certainty for Mr. Roy? Well, when you have arthritis, defendant's counsel, objection. Can we have the answer to does he have an opinion first? Plaintiff's counsel, I'll rephrase the question, Judge, for the clarity of the record. The court, I'd appreciate that. Doctor, do you have an opinion based on your clinical treatment of Mr. Roy and review of the records as to whether or not Mr. Roy, within a reasonable degree of medical certainty, is going to need future surgery on that left heel? Yes, I do. What's that opinion, doctor? That he will. Why is that, sir? Because he has pain with whatever little motion there is. He needs a fusion. What is a fusion? It's placing bone across the joint space so that that bone solidifies with the two bones that make up the joint space and prevent any motion from occurring. Where do you get the bone from that you are going to use to cover that joint space? Generally, a block of bone is taken from the hip area. What is going to be the practical result in terms of the mechanical functioning of Mr. Roy's left heel if he should undergo surgical fusion? Defendant's counsel, objection. The court sustained. You want to ask him if he has an opinion as to that? Plaintiff's counsel, I will, Your Honor. Thank you. Dr. Post, do you have an opinion within a reasonable degree of medical certainty about how fusion to Mr. Roy's left heel is going to leave him mechanically? I have an opinion. What is that opinion? That it will leave him permanently stiff. Will he have motion in that left heel? Absolutely not. Will he have a limp as a result of this fusion? He has a limp now, and the limp isn't going to go away. If anything, it will get worse. Doctor, I want you to assume that earlier today, Mr. Roy shared with the members of the jury how the accident occurred on October 16th of 1996. I want you to assume that he told us that on that day he was working atop an 18 to 20 foot scaffold, that he took a step on a plank that was unsecured, that hung over the left heel, that hung over the top of the scaffold, and when he did, the plank went up and he came down. Will you assume that? Yes. He testified to the members of the jury that at the time of this accident he weighed approximately 170 pounds, and that when he fell from this 18 to 20 feet, he landed squarely on his left foot. Would you assume that? Yes. Do you have an opinion within a reasonable degree of medical certainty whether or not that type of accident is the competent producing cause of the fracture that you observed and learned about in your course of treating Mr. Roy? Yes, I do. What is that opinion, doctor? That it was. Why is that? Defendant's counsel, improper, Your Honor. The court, that is proper. A fall for some feet, as you describe, is a general competent producing cause of this type of fracture if you land on the heel. Dr. Post, you shared with the members of the jury your course of treatment of Mr. Roy. You testified that Mr. Roy shared with you as his treating physician complaints of pain in that left heel, difficulty in walking on that left heel. You talked about swelling to that left heel, limitation and weakness in motion of that left heel, difficulty standing on that left heel, the necessity for him to use a cane in ambulating or walking around. Do you recall that? Yes. Do you have an opinion within a reasonable degree of medical certainty as to whether or not those symptoms are consistent with the fracture that you observed, the subsequent surgery, and the residual effect? Yes, they are. Defendant's counsel, objection. The court, what's your objection? Defendant's counsel, form and substance. The court, I'll sustain it as to form. Doctor, the complaint that Mr. Roy shared with you, do you have an opinion within a reasonable degree of medical certainty whether or not that was caused by the left fracture? Yes, I do. What is that opinion, sir? That it was. Why is that? Again, as I just stated, the fall was a competent producing cause of this fracture. The fracture was badly comminuted, displaced intra-arterially, and is a cause of a constant source of pain. Dr. Post, in these complaints of pain and limitations in Mr. Roy's left heel that you've learned from him over this course of years, do you have an opinion within a reasonable degree of medical certainty as to whether or not those complaints and symptoms are permanent? Yes, I do. What is that, sir? That they are. Dr. Post, when Mr. Roy first came to you on March 20th of 1996, immediately following or approximately 1 week after his March 13th, 1996 accident, he was making complaints to you about his lower back and radiating pains into his legs. Is that correct? Yes. You shared with the members of the jury your course of treatment between March of 96 and August of 96 when he ultimately returned to work. Is that correct? Yes. Dr. Post, during your course of treatment and after reviewing the records and EMG reports of
I didn't have time to incorporate those different doctors though. Like,
what do you mean?
like whether it was Nish Cap or
Whether it was what?
Director
Oh
Dress
yeah,
or
that doctor thing.